last time and tried to conduct the arraignment, and you ended up being held in contempt, and so we're continuing the arraignment to today's date. So let's try again. All right, so Mr. McLeod, I've got to obey the dictates of All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. And we'll call the case of People of the State of Michigan versus Trevor McLeod. It's file 23-6748FH. How do you interrupt the table, please?
All right, sir.
Very good. Mr. McLeod, we were here last time and tried to conduct the arraignment, and you ended up being held in contempt, and so we're continuing the arraignment to today's date. So let's try again. All right, so Mr. McLeod, I've got to obey the dictates of the Michigan Supreme Court, and they make me go through certain things. Sure. You're here without a lawyer. So I need to obey the Supreme Court and establish certain things so that I can make sure that you can represent yourself. So you've got the right to represent yourself or to have an attorney represent you. You can't do both at the same time. So I need to establish which one you're choosing. So to do that, I have to first advise you of the maximum charges that you face. Count one is a charge of resisting obstructing a conservation officer with habitual second notice, which makes it a felony punishable by up to 3 years and or $1,000 fine. Count two is operating a motorboat while intoxicated. That's a misdemeanor, punishable by up to 93 days and or $100 to $500 fine and or 45 days of community service, suspending the privilege to operate a vessel, cost of prosecution, or emergency response. Mr. McLeod, do you understand the maximum possible sentences for those charges?
Can I say something for the record?
No. I'm asking you a question. Do you understand the maximum punishments that you face?
I don't accept those charges. I got a treaty right here that says I wasn't doing anything wrong.
That's for later. All right, Mr. McLeod, you apparently want to do this the hard way again. I'm just asking you if you comprehend the maximum penalty that they're charging you.
I comprehend.
Okay. Right. So, do you understand that you have the right to an attorney, either hired of your own choosing or provided at public expense? Do you understand that right?
I comprehend.
Okay. Do you wish to have an attorney represent you, or do you wish to represent yourself?
I'm presenting myself. I'm here by special visitation as opposed to general appearance or lack of subject matter jurisdiction because the 1836 Treaty of Washington, which was further codified in 2017, states that my vote does not need to be registered, which makes this unlawful investigation fruit of the poisonous tree.
Okay, so you wish to represent yourself in this?
I'm presenting myself.
Okay. And has anybody promised you anything or threatened you in any way to get you to waive your right to an attorney, or are you doing that of your own free choice?
It's not a my free choice, it's under duress. But I'm here to so.
Oh, you mean that you're not choosing to be here because of the charges? I just mean, so nobody's like making you give up your right to an attorney. Well, I said you got the right to an attorney. You don't want to have an attorney. Is that your choice, or is somebody like pressuring you to not have a lawyer?
Who's pressuring you to be here?
That's not what I asked.
Okay. Well,
is anybody pressuring you to give up your right to have a lawyer?
No.
Okay. See, I'm not asking you trick questions. I promise you, Mr. These are not trick questions. All right. So I'm also required to make sure that you are doing this with open eyes, meaning that you understand the risks of self-representation. So as you found out last time, this court has procedures that this court will follow. And when people refuse to follow them, there will be consequences for that. If you're representing yourself, you're going to be held to those same procedures just like a lawyer would. Do you understand that? Do you comprehend that?
I comprehend that this court does what it wants and violates the due process when they arrested me, so we lost subject matter jurisdiction. This whole thing is a shame.
That's not what I asked you.
Okay.
Do you comprehend that I'm going to hold you to the same standards of procedures that I would to an attorney?
I don't think that's how it should be done. I think there's case law that says that people, when people present themselves, they have different standards.
Well, they don't. I mean, I try to work with them as I am with you. I can promise you I don't have these types of conversations with lawyers at the arraignment because they know what they're doing. So I'm trying to give you a little bit more leeway. But you have to follow the procedures as they are dictated by the Supreme Court and the court rules, and as I say them to be. Not what you think they ought to be, but what I say they are. Do you understand that?
I don't understand. I comprehend it.
Okay. All right. Now, because of that, attorneys have had to, be licensed to understand those rules and have degree from a law school where they've spent 3 years studying those rules. And so there may be things that they're aware of that you may not be. So when somebody represents themselves, there may be a defense to the charge where a lawyer might recognize that defense and present it, and somebody representing themselves might miss that defense. So when you represent yourself, you take the risk of that happening. Do you comprehend that? All right. So let me give you an example of that. About 2 years ago, I had somebody in my court in my other county, similar to your beliefs about the law. And this defendant was raising similar claims as you're seeking to raise here. And they didn't prevail because courts don't agree with those claims. And the person became so disruptive, I withdrew their permission to represent themselves, and I appointed an attorney for that person against their will. The attorney recognized that there was a defense to the charge, filed a motion, and I dismissed the case on the attorney's motion. The person representing themselves would have never recognized or did not recognize that defense. So do you understand, when you represent yourself and give up the right to be represented by a trained attorney, you're taking a risk that there may be defenses that you might miss.
I comprehend what you're saying.
Okay.
So I think you just move forward from the attorney.
All right. So then the final thing that I have to decide is whether your self-representation will disrupt, unduly inconvenience, or burden the court and the administration of the court's business. If I'm judging it just on last time's appearance, I would say, well, yeah, you're going to be disruptive, so I'm not going to let you represent yourself. Today, you've been tempted to go down that road, it seems to me, but you've trained yourself. So I'll at this point find that you representing yourself is not going to unduly disrupt, inconvenience, or burden the court's business. But you should understand, Mr. McDowell, that changes. And you decide that you're going to run this court, which you do not. Then I will withdraw your authority to represent yourself, and I'll appoint an attorney to speak for you, and you won't be allowed to speak. But as long as you're going to, follow the proper procedures, at this point, I'll let you represent yourself. All right. So I will find that Mr. McLeod is unequivocally waiving his right to counsel. He's made that right knowingly, intelligently, and voluntarily, and he's aware of the disadvantages of self-representation. And at this point, I'm finding that his self-representation will not be disrupted to the court's business. All right. There. Now, Mr. McLeod, I have to arraign you on the charge itself. Have you been given a copy of the document called Information Felony, the charging document that contains the charges against you? Okay. You would have the right to have me read that document in full on the record. Do you wish me to do that, or do you want to waive the reading of the information?
I guess it's for procedure. Go ahead.
Okay. So count one charges you with resisting, obstructing conservation officers, and it alleges that you did knowingly or willfully obstruct, resist, oppose, assault, beat, or wound C.O. Layston Feltz, an officer appointed by the Director of the Department of Natural Resources when said person was making an arrest or search contrary to Michigan law. That's normally a high court misdemeanor punishable by 2 years and or $1,000 fine. There is a habitual offender second notice indicating that the court should take notice that you were previously convicted of a felony or an attempt to commit a felony in that on or about February 12th, 1996, you were convicted of the offense of larceny from a motor vehicle, violation of Michigan law in the 53rd Circuit Court for Sheboygan County. Therefore, that increases the maximum penalty to 1.5 times, meaning that resisting obstructing charge is punishable by a maximum of 3 years and or $1,000. Count two, marine safety operating while intoxicated, alleges that you did operate a motorboat on the waters of the state while you were under the influence of alcoholic liquor contrary to Michigan law. That's a misdemeanor punishable by 93 days and or a $100 to $500 fine and or 45 days community service. Court to suspend privilege to operate vessel 1 year to indefinite, and the court can assess the cost of prosecution or emergency response. All right. Mr. McLeod, how do you wish to plead to those charges? You can either plead guilty, not guilty, or you can stand.
I don't plan on pleading because I have a decree right here that says I wasn't violating any laws. Stop it unlawful, which makes everything after approved before it's true. So
Well, that's
for evidence. Copy of my travel card, a copy of the excerpt from the 2017 consent decree.
Well, that would be like a motion to dismiss later on, which you could file. In fact, you had filed a couple motions to be heard today, and then you withdrew them. If you file motions and want them heard, I will hear them. I'll hear your arguments, and I'll rule on them on the merits and the law and the facts. But you can't skip the entering of a plea and go right to a motion. So I first have to enter a plea, either guilty, not guilty, or you can stand mute and refuse to enter a plea. Am I understanding that you are refusing to enter a plea? Which is fine. That's not a violation of court procedure. It's one of your options. You have 3 options right now: to enter a plea of guilty to the charges, to enter a plea of not guilty to the charges, or to decline to enter a plea to the charges. Which of those 3 options?
I decline any plea.
Okay. That's fine. That's your right to do so. So Mr. McLeod is standing mute as to the charges. The court will enter a not guilty plea on his behalf.
I checked for that, Your Honor.
Well, I'm sure you don't want me to enter a guilty plea, so I have to enter one or the other.
I'm guilty on behalf of the practicing law for the bench. So are you finding a judicial determination that I'm not guilty?
I do not have to subject myself to your cross-examination, Mr. McLeod. That's not how this works. All right, so I'm going to enter a plea of not guilty on your behalf. Mr. Juliet, are the people requesting a referral to the Forensic Center?
No, Your Honor.
I don't see any indication that Mr. McLeod is incompetent to stand trial, so I won't make such a referral on a court's own initiative. All right, so Mr. McLeod, the other thing I have to do today is kind of pick a day for us to come back, hear any motions that you may file and schedule, or the prosecutor may file and schedule, or to see if there's a resolution of the case, or to schedule a trial. And we call that a docket call, because we're calling the case to the docket. So I've got to pick a docket call date. We usually do that about a month out. So I could have you come back Tuesday, February 6th at 9 a.m. Juliet, what would be the estimated length of trial if the case went to trial?
1 day.
All right, Mr. Juliet, anything further from the people?
I received an email yesterday from Mr. McLeod. It appears to be a dispositive motion to, I would say, suppress the evidence. I know he filed a motion based on summary disposition a while back that was withdrawn. I would just request that if he wants to move forward with that motion to suppress, just give us a copy of the written motion. Perhaps the court can hear it on the 6th. I would just ask 7 days to respond to it.
All right. So, Mr. McLeod, I've done everything I need to do today in terms of determining whether you can represent yourself, advising you the charges, entering a plea, and scheduling our next court date. You can feel free to file any motions or objections that you want to have heard to be heard on that date. I can't rule on things orally on that regard. It sounded like today you wanted to tell me some things about a treaty and things like that. You might be right. I don't know. But I'd have to review your written materials. I'd have to review your argument. I'd have to hear from both sides and then make a decision on that. We can do that on the 6th if you file the motion and notice it up to be heard that day. Is there anything further for purposes of arraignment today?
I'd like to have the motions heard earlier than that. And I'd like to be reviewed to my bond restrictions, which are quite invasive, honestly.
Well, you filed a motion to review those and then you withdrew your motion.
Because I want to do it separately.
I mean, well, I guess I could make one exception to that the court rule does allow bonds to be reviewed at any time. So I do allow oral motions to review bond. So if you want to talk about your bond conditions right now, I'll certainly do that.
I think they're very restrictive. I think they're a violation of due process. I think that they're unnecessary to prove that I'm going to show up or that I'm not dangerous to the public.
And what those conditions are, because I didn't set them. Those are set by the district court. So let me review here. Which conditions is it that you are thinking are unduly restricted?
Having to call every morning to take a drug test. So,
is that the only condition you're seeking to have removed?
it's really the only one that, well, not being able to leave the state is kind of silly too. I travel for work.
All right, Mr. Juliet, Mr. McLeod is objecting to the bond conditions of calling the bond line for testing every day and not leaving the state of Michigan. Any response?
If he works out of state, I have no objection to that. We're striking that from the bond condition. As far as the bond line, I mean, this is an alcohol-related offense. It has been a while. I mean, there's been no bond violations, so I don't have any objection to the board striking here.
Okay, now the initial conditions downstairs did say except travel for work purposes. Or, I mean, looking at this charge, I've got a misdemeanor charge. I've got a fairly low severity felony charge. So, I mean, if Mr. McLeod, if you didn't show up for court, that would be a problem. But if you wanted to, go to another state for work or frankly for any other reason, I'm not sure why I would care about that. I don't think this is the kind of case where you would pose a flight risk. So I am going to amend the bond conditions to remove the bond line requirement. And remove the restriction on out-of-state travel. If this were a drunk driving charge with a motor vehicle, I don't think I'd remove that because I think I'd still want to have you do testing, but I'm really not too worried. You're going to be operating a motorboat right now anyway, so I'll grant that request from Mr. McLeod and remove those two bond conditions. The court will enter an order so that you don't have to present one to us, effectuating those changes. Anything further for today, Mr. McLeod? Okay, we'll see you on the 6th. If you do want your motions heard on an earlier date, you can contact the assignment clerk and see if there's a date we can get you in soon. All right, have a good day.